Good morning. When Michael asked me to participate in today's conference by introducing the keynote speaker, I puzzled for a while as to how best to carry out the office of a historian in a room full of lawyers. Now, the role of the historian is normally to provide background on origins and context, so I began by rereading some of the central literature on the German example of the attempted genocide of European Jews, German history being the focus of my own research. And I found myself drawn, of course, to the work in which, in 1944, Raphael Lemkin, about whom we'll hear more all day, but who most materially is important as the drafter of the Genocide Convention, whose negotiations we commemorate today, and who in that work coined the neologism genocide. I was struck by two aspects of what he wrote, and I think that these observations can perhaps serve as the added value that I, as a historian, can bring to our explorations today. First, Lemkin's famous Chapter 9 in his book Axis Rule in Occupied Europe, Laws of Occupation, Analysis of Government, Proposals for Redress, expressly denoted genocide as being, quote, a new term and a new conception for destruction of nations. He explained how genocide consisted of two phases. First, the destruction of the national pattern of the oppressed group, and second, the imposition of the national pattern of the oppressor. And he went on to analyze, in order, techniques of genocide in various fields: political, social, biological, physical, religious, and moral. Now, as part of the literature of critique of the insufficient reach of the Genocide Convention itself, many observers have commented upon its limitation to, quote, a national, ethnical, racial, or religious group in Article 2. But few commentators have noted the second aspect of the narrower scope that the Convention has as compared to Lemkin's definition. Namely, Article 2 defines the crime of genocide exclusively as acts directed toward what Lemkin calls the biological and physical techniques of genocide, without mentioning the political, social, religious, and moral. While Lemkin certainly condemned the biological and physical efforts to extinguish national identity that characterized German policies in occupied territories between 1939 and 1945, he also condemned the less lethal but no less threatening measures in the political, social, religious, and moral realms. Now, we all know that the Convention itself excluded politically motivated murders because of the objections of Stalinist-era Soviet Union. But I want to make a separate point. Lemkin's broader definition of genocide, the one that extends beyond mass murder to include political, social, religious, and moral measures to efface group identity, moves the onus of the crime of genocide away from exclusive focus on mass murder, condemnation of which can easily be found by appeal to generalized principles of humanity, to a broader concern with the defense and protection of multiple minority national identities. To Lemkin, genocide was not just a crime against humanity, but it was a crime against nations. And Lemkin's whole analysis thus began deeply rooted in the era of high nationalist ideology, the doctrine that so bedeviled Europe that Mark Matzover has called his recent text, Dark Continent, Europe's 20th Century. I hope that during the day we can explore some of the implications of the highly nationalist origin of Lemkin's concept in an era in which around the world consensus has turned away from biological notions of national belonging, and in Europe at least, many hope that we have reached a broadly post-nationalist period. The second thing that struck me about Lemkin's book was the structure and content. The book is largely a compendium of descriptions of the administrative and legal rules whereby Germany administered the various states and territories that it occupied all over Europe, followed by a 400-page appendix of translations of these legal rules. Genocide, it seemed to Lemkin, originated in law. Students of the history of Germany have long known that the so-called NS-Unrechtsstaat, National Socialist State of Injustice, was really a welter of the formalisms of administrative and regulatory law. One need not enter the argument about the role of legal positivism in solidifying support for National Socialist rule in order to observe that bureaucratic administration of vast conquered territories, as well as of organized industrial mass murder, require regularity in rules, classifications and categories, and that law and lawyers are inevitably imbricated in such processes. Diemut Meyer's massive analysis, called Non-Germans Under the Third Reich, recounts in 1,031 pages of excruciating detail the varying legal systems that the National Socialists used to govern minorities, first in pre-1937 Germany, then in the parts of Poland either annexed or anticipated to be annexed to Germany, and finally in the general government of Poland, which was not intended to be annexed. Far from being lawless, in scare quotes, genocide requires law. One might say that law is indispensable to genocide, at least in the German case, which has in many ways, for good or ill, been the defining one. But if in Germany law was indispensable to genocide, the convention we gather to commemorate, drafted by Lemkin and wielded by courageous and intrepid lawyers and judges, argues the counter proposition, namely that law is also indispensable to deter, to prevent, and to punish genocide. As successors to Lemkin, many of today's speakers have been active participants in the application of the Genocide Convention, as well as scholars equally devoted to Lemkin's cause of eliminating as well as condemning this crime. Few scholar participants better personify this commitment to the use of law as a tool against genocide than today's keynote speaker, Juan E. Mendez, president of the International Center for Transitional Justice in New York. A native of Lomas de Zamora, Argentina, Mr. Méndez began his career as an advocate for political prisoners in his home country, resulting in his own detention and torture in the 1970s. Since coming to the United States soon thereafter, he has worked with Human Rights Watch, the Inter-American Commission on Human Rights of the Organization of American States, as well as directing the Inter-American Institute of Human Rights in Costa Rica. And he has taught at the University of Notre Dame Law School, Georgetown Law School, and the Johns Hopkins School of Advanced International Studies. Until he joined the ICTJ earlier this year, he was special advisor to the Secretary General of the United Nations on prevention of genocide. We are honored to welcome Mr. Méndez to our conference today as he speaks to us on the history of genocide.
Thank you, Professor Ledford, for that introduction, and thank you also for speaking about the history of genocide, because those of you who know me know that I am not an expert on that. If anything, I'm going to give you a very short history of the very early efforts of the United Nations to try to learn the lessons of the past and to prevent genocide in the future. And it is a short and still struggling history, but I think it does bear some discussion. So I am very grateful to the Case Western Reserve University Law School for this invitation to speak at this important conference, and it is a great pleasure to be here in front of a very distinguished audience. My presentation will concentrate on the importance of prevention of mass violence and international crimes, including genocide, and I will do so mainly from the perspectives of the programs that my organization, the International Center for Transitional Justice, conducts in several countries, but also from the experience that I had until April of this year as the Special Advisor to the Secretary General on the prevention of genocide. And in fact, I held those two positions concurrently for 30 months. Breaking the cycle of impunity and fostering accountability is a crucial component in the prevention of future violence and mass atrocities. No prevention efforts can take place without a serious attempt to break the cycle of impunity for past human rights violations, especially if they are so widespread or systematic as to constitute war crimes, crimes against humanity, or genocide. If perpetrators feel shielded from prosecution or investigation for the crimes they have already committed, they will have an incentive not only to commit them anew, but also to raise the stakes and perpetrate even more serious crimes. The failure to do justice to the victims usually leads to sentiments of revenge, and thus to the likelihood of more crimes. Accountability is essential to halt the vicious cycle of revenge, but also to enable the victims to make their own decisions as to their protection and well-being, so that they're not merely passive recipients of the international community's efforts to protect them or to provide them relief. Finally, accountability for past crimes is also important so that the victims, their families, and communities can distinguish between their victimizers and the communities those victimizers claim to represent, so that the blame for the atrocities is not visited on innocent descendants of those perpetrators. It must be understood, however, that prevention of genocide will require more and different measures. Bringing the perpetrators to justice will not be enough. Prevention of genocide will require early warning and reasonable suggestions for early action. The office I held for 30 months, at the request of Secretary General Kofi Annan, was the first attempt by the United Nations to apply lessons learned and correct the structural weaknesses that caused the UN to fail to prevent genocide in Rwanda and in Srebrenica in the 1990s. In this respect, I have to say that one of the challenges, difficulties, was that we still use the paradigms of Rwanda or the Holocaust to decide whether to act or not. And so for every case that one has to make, if it doesn't rise to the level of seriousness or gravity or speed of Rwanda, then the tendency is to look away and say, well, it's not genocide and it's not going to be genocide, so there's nothing that we should do. And fighting that tendency was one of my more difficult challenges, and I wouldn't say not only with nation states, but also within the Secretariat of the United Nations. As a very preliminary observation, my experience demonstrates that early warning and early action can serve important purposes. Still, the bottleneck is a political will to act that is almost never present from the start. In that sense, the role of the Special Advisor is, I think, primarily directed to contribute to shape and create that political will, in conjunction with public opinion, caring institutions, willing democratic states, and common men and women around the world. I am also glad to report that following a strong report from the Advisory Committee on the Prevention of Genocide, of which I continue to be a member, the new Secretary General has appointed a full-time Special Advisor and named the distinguished African jurist Francis Deng to the post. In addition to his full-time duties, he will be assigned more resources and his job will be elevated to the rank of Under-Secretary General. The latter is crucial to ensure direct contact with Mr. Ban and through him to the Security Council, since the Security Council is, through its Resolution 1366 of the year 2001, the source of the Special Advisor's mandate. The task enjoys great legitimacy because of the universal recognition that the Convention to Prevent and Punish the Crime of Genocide of 1948 has become jus cogens. In addition, the outcome report of the 2005 summit offered an additional source of legitimacy to prevention of genocide in the adoption of the responsibility to protect doctrine. Nevertheless, both sources of legal and moral support are unfortunately qualified. In the case of the Genocide Convention, disputes over the definition and about whether the facts on the ground constitute genocide have often become a substitute for serious action. In our activities, we had to stress frequently that our task was to prevent, not to adjudicate. It follows that my office was not called upon to make such a judgment, but rather to generate action before all the elements of the definition were in place. For that reason, it was imperative to act on situations of mass violence against vulnerable populations defined by their ethnicity, race, religion, or national origin, whether or not the attacks they suffered amounted to genocide, and to let a court of law eventually decide what they amounted to. With respect to the responsibility to protect, regretfully, there are now many revisionist theories about what the relevant documents meant to say. Some states express distrust that responsibility to protect is just a new code word for humanitarian intervention, and therefore, in their view, a rationalization for superpower non-consensual interventions. That this debate is hampering the creation of relevant offices in the Secretariat to operationalize the responsibility to protect doctrine is a clear indication that there is still a lot to be done in the battle of ideas. In terms of early action, the challenge is to come up with suggestions that are practical, but at the same time are not just token gestures. In that sense, non-consensual military intervention should never be ruled out, because in some cases it will be the only way to save lives. But before advocating use of force, we also must be certain that we're not going to do more harm than good. And that is always contingent on the facts on the ground and their context. Between doing nothing and invading, there is a wide spectrum of actions that can and should be taken on a timely basis. In my experience, primarily on Darfur, but extrapolating it to other situations as well, I have learned that effective prevention must rely on acting simultaneously and in a concerted way in 4 areas: physical protection of the population at risk, humanitarian relief, promoting peace talks to end the underlying conflict, and breaking the cycle of impunity for the crimes already committed. I stress that in each of these areas the actions must change and be adapted to evolving circumstances. More importantly, they should be implemented simultaneously and in coordination, and we should not allow any one of them to become the condition for the other in a sort of vicious circle like in Darfur, where each one of these actions are so dependent on obtaining consent for the other that neither one of them are ever fully implemented. In keeping with the theme of this conference, I'd like to concentrate, however, on the 4th and last of those areas of preventive action. Accountability for war crimes and crimes against humanity must be comprehensive, balanced, and holistic, meaning that policies and practices must address the need to discover and disclose the truth, to bring perpetrators to justice, to offer reparations to the victims, and to promote deep reforms in the institutions through which state power is exercised. In cases where the violence has clear ethnic dimensions, like in Darfur, they must be accompanied by reconciliation initiatives aimed at fostering serious intercommunal conversations without outside interference about return to homes and villages, property restitution, water, grazing, and passage rights. While criminal prosecution should not be the sole response to impunity, there is no doubt that they must play a central, indispensable role in any policy of accountability. Prosecutions also represent the state's fundamental obligation to give victims access to justice. In addition, concerning international crimes, states have a clear international legal obligation to ensure that justice is done. This is particularly the case for serious violations of international humanitarian law. In relation to war crimes, the Geneva Conventions of 1949 and Additional Protocol 1 establish a duty for states to prosecute and punish those responsible for grave breaches of international humanitarian law. Although it was once understood that the category of grave breaches applied to international conflicts only, a customary international law norm is emerging that applies it also to conflicts not of an international character. If a state party is unwilling or unable to prosecute war criminals, it must hand them over to be prosecuted by another state party under the audedere aut judicare principle. In the post-World War II era, therefore, international humanitarian law created a new set of obligations which in turn paved the way for the enforcement of these norms. To foster accountability for such crimes, a dual approach should be favored. On the one hand, the international community must pay more attention to helping states live up to this obligation by building independent, impartial judiciaries that can prosecute mass atrocities with full respect for due process of law and fair trial guarantees. On the other hand, our support of the role of the International Criminal Court and other international or hybrid criminal jurisdictions must be oriented towards supplementing the absence of will or capacity to produce fair trials domestically, but also to help generate the capacity in the future. This year we celebrate the 100th anniversary of the 1907 Hague Rules, as well as the 30th anniversary of the 1977 additional protocols to the Geneva Conventions. In the 70 years which elapsed between those two dates, 1907 and 1977, the world suffered world wars, the Holocaust and other genocides, and many terrible war crimes. But these years have also marked the codification of the body of international humanitarian law, the materialization of the principle of individual criminal responsibility at the international level, and the strengthening of all forms of accountability for these crimes. The near universal ratification of the Geneva Conventions bear witness to this reinforcement of international law, and in particular of international humanitarian law. If we only just look back to less than 15 years ago, we see how far we have come from the pervasiveness of impunity for grave human rights crimes and from the permissive attitude towards that impunity by the international community. Since 1993, we have notably witnessed the establishment of the International Criminal Tribunals for the former Yugoslavia and for Rwanda, of the Special Court for Sierra Leone, of the extraordinary chambers in the courts of Cambodia, and of other hybrid mechanisms in East Timor, Bosnia-Herzegovina, Kosovo, and recently Lebanon and Guatemala. Important, too, are efforts to prosecute those crimes in the domestic level, in Argentina, Peru, Colombia, Rwanda, Ethiopia. The creation of the International Criminal Court in 1998 was the high point of this evolution, signaling that accountability for war crimes, crimes against humanity and genocide is now paramount. But the Rome Statute is not only the culmination of a clear historical trend, it is also the means to establish an instrument that makes justice possible when the national domestic jurisdictions are unable or unwilling to afford it. And yet, for each situation in which the ICC has acquired jurisdiction, we hear voices calling for amnesty, withdrawal of indictments, or other forms of exercising discretion and avoiding prosecutions, supposedly in the name of peace. With the best of intentions, some are urging measures that implicitly give in to the blackmail of the parties to the armed conflict. Peace can only come if those accused of atrocities are given guarantees that they will not be touched. We are concerned by the revival of this debate that some of us had hoped would by now be more settled. To those who have followed the evolution of human rights in the last 25 years, the debate rings of earlier discussions as to whether fragile democracies could really afford to investigate and disclose, let alone prosecute, the major crimes of the preceding era. The alleged antinomy between justice and democracy, often rephrased today as the tension between peace and justice, is debated in academic circles and also among practitioners. A major conference was recently organized by the ICTJ with others in Nuremberg to discuss this tension and to explore possible ways in which peace and justice indeed can be made mutually reinforcing. In northern Uganda, while there is a broad recognition that the ICC arrest warrants have assisted in bringing the Lord's Resistance Army leaders to the negotiating table, some have portrayed those warrants as obstacles to progressing further with the peace process. We believe, however, that the warrants act as an incentive to keeping the LRA involved in the peace talks. We also welcome the signature of an agreement on accountability and reconciliation between the LRA and the government of Uganda that was signed on 29 June of this year. The agreement proposes that Uganda should implement its international obligations to prosecute senior leaders of the LRA under national law. Depending on what is proposed to implement it and on what effectively is finally done, we believe this course of action may be consistent with the Rome Statute. A thorough national accountability process respecting international standards could have a wide-reaching impact in Ugandan society. We believe that the robust approach taken in this preliminary peace agreement towards accountability is an important improvement over past peace accords, and that the pressure brought to bear by the ICC has assisted to achieve this. At the same time, the international community must stand ready to continue its support to the ICC if either side reneges on the agreement. There are many examples of the impact that prosecutions, or even the threat of prosecutions, can have in preventing crimes, including war crimes. In Côte d'Ivoire, the prospect of an ICC prosecution for those who used hate speech to instigate and incite to commit international crimes has arguably kept those actors under some level of control. It is also an important example of the possible preventive role of the International Criminal Court. In Colombia, alternative sentencing and demobilization of the paramilitary groups under the Justice and Peace Law, as originally drafted, would have left victims with no prospect of justice for the harms they have suffered. The need to offer a semblance of compliance with the international standards set forth in the Rome Statute have produced important amendments during the legislative process of that law, but then they were further strengthened by a constitutional court ruling based precisely on the need to bring the law in line with the state's international law obligations. While the Justice and Peace Law, as amended, now shows important innovations, it also shows some of the tremendous challenges in dealing with large numbers of perpetrators and victims through a system that encourages cooperation with the law and disclosure as an alternative to full-fledged trials. In Darfur, which I visited in 2004 and 2005, impunity for earlier crimes, notably the massacres of 2003 that cost at least 200,000 lives, has been for too long a factor of instability and a hindrance to prevention of future crimes. That is why early on I joined those who called for a referral of the case to the ICC by the Security Council, a measure of historic significance that was adopted on April 1, 2005. Unfortunately, I come away with the impression that we were not always strategic or sufficiently persistent in pursuing a multi-pronged approach to protection, humanitarian assistance, peaceful settlement of the conflict, and criminal accountability. It has now been 2.5 years since the Security Council referred the case to the ICC, and the government of Sudan has repeatedly stated that it does not recognize that decision and that it will not cooperate with the Office of the Prosecutor's investigations or the arrest warrants issued this year against Harun and Kushaib. In that long period, the Security Council has made no effort to remind the government of Sudan that this was a decision adopted under Chapter 7 of the Charter and therefore binding on all states. Instead, we have let the regime get away with defiance of a resolution adopted in furtherance of international peace and security. As far as I can see, only the High Commissioner for Human Rights and my Office of Prevention of Genocide have raised this point from time to time. The result is not only that we do not offer the ICC the support it needs, it is also that we have given away cards that we could have used in negotiating with Khartoum to better protect and assist the 3 million Darfuris who are now totally dependent on international assistance and to reach a serious peace agreement as well. In the DRC, reports of crimes are also still surfacing, as for instance the massacre of Kasika. Many crimes are still being committed, particularly against women and girls, in a widespread manner, notably in the Kivus. The fight against impunity has barely started in this huge country. We hope that the trial at the ICC of Thomas Lubanga Dilo will soon be followed by other cases so as to give an account of the many horrific crimes committed in this country since 2002. But there is also an acute need in the DRC to foster accountability for the many crimes committed before 2002. It is critical that domestic courts be enabled and empowered to try those responsible, including those bearing the highest level of responsibility. ICTJ is currently co-undertaking a survey to better understand the extent to which people have been victimized in the DRC. Another project which will pave the way to fostering accountability in the DRC has been developed by the UN Office of the High Commissioner for Human Rights together with MONUC, the mission of the United Nations in Congo. It concerns the mapping of the serious violations of international humanitarian law and of massive human rights violations which have taken place in the DRC over the last few years. Such mapping will not only gather and preserve crucial evidence, but also provide a new impetus to advocacy on the need to bring those responsible to justice. The long-term stability of this vast country, situated at the heart of Africa, is at stake, and much more needs to be done to ensure that the plight of the Congolese is addressed in accountability terms. What all these cases demonstrate is that ultimately the interest of justice and the interest of peace cannot and should not be divorced. Justice is an important component of the prevention of future crimes. It is only through justice and through enforcement of the law that long-term respect for the rule of law can be built. This provides us with an important lesson for all international and hybrid jurisdictions. They must seek more proactively to build their legitimacy in affected regions so as to build their own relevance in the lives of those most affected. Most importantly, these jurisdictions are judged on the basis of their impartiality and professionalism. To be seen as legitimate and respectful of universal standards any perception of selective prosecution not based on rational choices should be avoided, or at least carefully explained. Those of us who support this jurisdiction should learn to identify their impact and successes in ways that go beyond the strict confines of the judicial process. In cases such as Cambodia, this will depend on the legitimacy and transparency of the extraordinary chambers in the eyes of both Cambodians who suffered under the Khmer Rouge and the international community. This broader impact is all the more important for those international or hybrid jurisdictions which are being prompted to complete their work in the coming years. It is time to assess their work, but we must do it under a long-term view and not on the basis of their immediate political effect on the ground. It is also important to review their legacy and what remains to be done, with a view to help generate absorption and incorporation of that legacy into the national legal culture and domestic capacity to further their work. I'm running out of time, but I do want to mention one very recent landmark in this process that I think will make an important contribution. And I want to mention the efforts in places like Peru and Argentina, but the groundbreaking precedent that I want to mention has been established just last week by the Supreme Court of Chile in ruling in favor of the extradition of former Peruvian President Alberto Fujimori, at least for 2 counts of very serious human rights crimes. I am sorry to have run over my time a little bit, but I really again want to thank all of you for your attention. Thank you.
So we have 15 minutes for question and answer, and thank you so much for
Pleasure.
cutting your
Should I
speech in
recognize?
order to give enough for the people to ask you questions. If you have a question, just raise your hand. The microphones will be brought to you.
I will tend to step outside the scope of this symposium in that here we're concerned with finding the culprits and prosecuting them. How about education? I've never hear that word mentioned. You say we're trying to overcome genocide, but isn't it necessary that the education systems in these various countries be told and shown how to teach the proper way to approach individuals? Now, I do want to say, I don't know if this is part of your approach or not. You're the president of this International Center for Transitional Justice. That's an interesting term, transitional, because you're saying that prior to investigating or charging people, you do want to identify what is, excuse the expression, genocide. Now, isn't genocide a lot like cancer? We all know that there are many, many forms of cancer, and each of them requires a different remedy. Now, it seems to me that basically, if you go from micro to macro, on the micro side, we would say that genocide is the haves versus the have-nots. On the macro side, of course, you're getting into numbers. How many people do you have to intimidate before it becomes genocide? These are not factors that are made clear to me.
Those are three very difficult questions, but with respect to education, absolutely, prevention of genocide. All the prevention of genocide literature is full of references to that. I only want to stress that the Office of the Special Advisor is set up to act more or less at the last minute, kind of in the spectrum of prevention that can happen. It is not set up to act in long-term prevention, like generation-long prevention. There is some kind of incipient division of labor with other United Nations organs that can intervene at earlier stages. For example, the Committee on Elimination of Racial Discrimination has an early warning system that does operate in moments in which a pattern of discrimination threatens to become something that spirals into violence. The office that I held was not in a position to act that early in the process. It was more, not because we didn't recognize the need to do that, but but actually to be able to work with the Security Council in situations that otherwise the earlier efforts had already failed. Yeah, the other part of your question, transitional justice is becoming a term of art, and it's not a very good word because we have to explain it. It's not self-explanatory. But I want to stress that by that we don't mean to qualify the word justice. We only mean to recognize that in certain transitions justice has special challenges, and that the transitions can be from dictatorship to democracy or from conflict to peace. In all of those cases, doing justice becomes a special challenge, a different challenge than in normal times, and that's the only reason why we use transitional justice. But by that we mean basically the efforts that societies and states make to redress the wrongs of the past in the moment of transition or as the transition begins, so that the transition does not absorb the rights of the victims to see justice done. In that sense, there are practices around the world that can be, usefully studied and not necessarily applied in different settings, but can provide lessons that can be adapted to specific circumstances. In that sense, we believe there are universal principles that are actually emerging norms that oblige states to look at justice, to look at peace, to look at reparations, and to look at institutional reform. The methods by which they actually implement those obligations are contingent and culturally relative, but the principles themselves are not. They are universal.
Good morning, Mr. Mendez.
There you are.
I'm a first-year case law student. I'd like to know, you said that genocide in Germany and Rwanda set a high bar for UN intervention. And I would like to know how you believe the events in the former Yugoslavia changed international discourse on genocide, and if, in your opinion, those events specifically altered the UN standard for intervention.
Well, officially, quote unquote, in the United Nations, we can talk about genocide in Rwanda and in Srebrenica because other bodies have already recognized that that's what that was. It's amazing, but I couldn't say that what happened in Armenia was genocide because the United Nations, no body of the United Nations has ever recognized that to be genocide. So you have this kind of strictures that UN officials have to live with, and that applies to the standards that you mentioned. What I tried to say was that the paradigm of Rwanda is so present in the United Nations Secretariat that if you come and tell anybody, I'm interested in Côte d'Ivoire, there seems to be an ethnic problem brewing there, the first thing they say, but that's not genocide. And then you have to explain, well, I'm not saying it is genocide, I'm saying that, we don't have a crystal ball, but if things get out of hand, it could become something like genocide. And then you have to explain the comparisons with what was happening in Rwanda before 1994. Pretty soon people do understand it, and I would say that nation states also do understand it. And so it doesn't become that much of a problem for the exercise of the mandate. But still the mindset is, yes, we have to prevent genocide. But what is it that we have to prevent? We have to prevent, the 6-week, tragedy of 800,000, 900,000 people killed in 6 weeks in Rwanda. That's the kind of paradigm. And then if you compare to that, every other conflict, including Darfur, pales by comparison and is diluted in the interest of, in the interest and in the decision to act by the international community and even by my colleagues at the UN. That's what I meant to say, that we need to abandon the paradigm and start thinking about prevention, not about definitions. I think, quite frankly, in the case of Darfur, the fact that the U.S. administration insisted on calling it genocide did a lot of good in many different respects. It really stirred the United Nations into more action earlier on. but at the same time, it became such a divisive and paralyzing discussion that for years we were saying we had. It looked like we had to decide whether it was genocide or not before we acted. In fact, I had many times journalists ask me, "But don't you have to say it's genocide because otherwise you don't have the legitimacy to act?" Which I think is wrong both in the law and ethically. I mean, we have to act before it's genocide. We have to act even if it's only, quote unquote, crimes against humanity or war crimes. Can I recognize myself?
Sure, you have control.
Bill, then Roy.
Bill, just wait for the mic. It's coming. There you go.
In light of your last remark, would it not have been preferable to title your office the Special Advisor on Crimes Against Humanity?
Well, it's now changed names. It's called the Special Advisor on Genocide and Mass Atrocities, which is good. I was never, however, keen on eliminating the word genocide, because if you dilute the real, impact of the obligation of the international community to act on genocide, you also, first you dilute the importance of the office, but also you run into all kinds of field struggles with other organs of the United States, including the mandate of the High Commissioner herself. So I think the focus, a narrow focus on genocide and similar mass atrocities is better than just a more general nomenclature. I had Roy and then Professor Quigley. Do we have time for three?
Yeah, I think we'll take three questions.
And I'll be short in my answers too. Brief, I mean, not short.
Thank you, Juan, and also for your excellent presentation. I was just interested in if you could explain where Ogaden and the current violence that's going on there fits into the bigger picture. Who's doing what, and if anything, to both examine what's going on and address it?
Well, during my 30 months, there are conflicts in which we acted very publicly and conflicts that we followed, and we decided to act in a more quiet diplomacy kind of way, and conflicts that we just followed to see what to do later on. And the Ogaden and several other areas, several other conflicts within Ethiopia were those that we were looking at, and we actually did some quiet diplomacy. I did do an end of mission report that I turned to the Secretary General. He has not made that report public, but I think by now I can refer to it, and I do have it, so I can circulate it. It's only my modest suggestion to my successor as to what conflicts to look into and how. It's not just saying, pointing to a place in the map. You also have to tell them what can be done about early warning, about gathering the information, and about acting on it. Professor Quigley?
Yes, thank you. Yeah, I certainly sympathize with your dilemma in having to deal with whether...
You need the...
John Quigley. I sympathize with your dilemma in having to argue with people about whether something is or is not genocide for purposes of prevention. There seems to be an assumption that if something is genocide, then states have a duty to act. The Genocide Convention says nothing to that effect. It requires states to prosecute only within their own territory. So even if it is genocide, that doesn't necessarily mean, in my mind, that there is an obligation on the part of states individually or states collectively as the United Nations to act. On the other hand, when you're having to prove to people that something is genocide, that you don't obviously, as you say, want to get into an argument about the definition of genocide. On the other hand, to my mind, the Genocide Convention is satisfied when you have one person who commits an act that's defined in Article 2 with the requisite intent. I mean, it's a very low bar for what constitutes genocide.
No, I agree. But on the second point, we're still down to having to judge the evidence and to try to elicit the motive, the intent out of the evidence. But then we're already in the post-genocidal state in which the genocide has already happened. And so that's why it doesn't help with prevention. And I feel quite frankly that prevention has to, be completely divorced from the question of whether the facts on the ground meet the definition, because if not, we're always several steps behind. But I think I disagree with you on what the convention, what kind of obligation it creates. Maybe in a little bit of wishful thinking, and I realize that there are schools of thought here, but I've always acted on the notion that the convention creates a duty to prevent. Now, the problem is that it doesn't say how that duty to prevent is to be exercised. And that is a serious limitation of the convention as written. But it doesn't mean that we are free to decide whether to prevent or not to prevent. We need to find the ways, and we need to feel obliged to prevent. Now, that's why I have always acted on the assumption that the parties to the Genocide Convention have assumed that duty to prevent, and then how to exercise that duty is up to the circumstances of the case. Thank you very much.
Thank you so much.
All right, we're going to then take a 10-minute break and begin promptly at 9:45, and I'll see you all back here at that time for our next panel. Thank you.